quorum now. We have a really big agenda full of House bills that we'd like to get through today, but we also have members that will have to come and go with other commitments. So if you're speaking for a bill and no one's really speaking against it, you might want to think about whether you don't want to say too much for it in case you end up speaking against it. Does that make sense? Maybe not. We also have our tip jar as always, so if you are not a lawyer and want to remind us of that, you can come put some money in the jar. We will start with a word of prayer. Nobody's making eye contact. Senator Steele is. You want to open us up in a word of prayer? Which mic are you? 15?
15.
All right.
I could tell you 13 and have Hatchet do it.
That's fine. You want to switch it up? Leader Hatchet, would you like to do it instead? After I gave a speech about not wasting time, we're just wasting time. All right. Leader Hatchet.
I'd like to give a long prayer today, Mr. Chairman. Dear God, thank you for bringing us all together here today. Please be with us and guide us as we make decisions for the state of Georgia. In Jesus' name I pray. Amen.
Thank you for that. All right. As always, I promise everybody they can go first, but I'm going to stick to my promise with Chairwoman Cooper. Come on up and give us a second, because when I do this to my committee, all the bills were in order. Now they won't be. We're looking at House Bill 177. Of course, if you're new and you want to be heard on a bill, make sure you come up and sign up to speak. The sign-up sheets are out here, so if you're not signed up to speak, come up now and sign up if you want to be heard on a particular bill. I say if you're new in case you don't know the rule on that. House Bill 177, working off the version that passed the House, LC 570200. Is that what you have?
Yes, sir.
All right, the floor is yours.
Thank you, Mr. Chairman and members of the committee. I do bring you House Bill 177, and this bill, despite the fact that I'm wearing dogs on my sweater, it is not about pets. It's about control and the potential harmful when there is a domestic violence problem and couples are on the verge of separating and one person wants to leave and one person doesn't want them to, and how that person that does not want the other one to leave, the kind of things they do. Sometimes I wonder if the world can get meaner, but what's happening now? The family pet has become a way to hurt the other person, and people, usually men, not always men, are threatening to harm the pet, take the pet, or kill the pet. And they often do it in front of the children. Statistics show that most women that are in this situation will not leave when threatened by an issue like this. They know that that animals have become so important in our society. They are like family members, whether you want to believe that or not. Think about your pet, your dog, your Labrador Retriever, your bulldog. If somebody threatened to kill it or take it and never let you have it back. So this is what this bill does. It allows a judge, if they want to, it's not mandatory, to add what will happen to the family pet, who's responsible for it, and any protection they want to have to a temporary protective order. And they don't have, like I say, they don't have to, it's not mandatory, but it allows them to do it, and it will also allow on the form that people fill out, the person that's trying to get the protective order, to have it where they can, if there's been a problems with the pet, they can add that to it. And the judge sees it, and the judge makes the decision. I'll be glad to answer questions.
Any questions from the committee for the author?
I will say it did come from Judiciary, and I, unlike another bill I had that they spent 18 hours on the bill, a page and a half over 3 days, this one came out unchanged, and will always remember what happened. When the bill passed, up went one phone with their pet on it, and up went another, and before I knew it, everybody had their pet phones up, and I've already had somebody with their pet.
So you're telling us the bill was not vetted in the House properly.
Okay.
Now we have lots of questions.
Oh, dear.
All right.
Sorry, sir.
All right, no questions from the committee.
Okay. I have asked if anybody, because of what your schedule is, and they signed up, but I've asked them if they're in favor of it, just to please stand up and say in favor, but I don't control who's.
I don't have anybody signed up in opposition to the bill, do I? I believe there was one issue with the sign-up sheet. So do anybody want to speak against this bill? All right. Now, there's 3 individuals who want to speak for it. It's Karima Dillard, Dr. Jennifer Bivens, and Lisa Mello. And you all want to stand up or come up and speak?
Please support the bill.
Support the bill? All right. Thank you all for your work. What's the pleasure of the committee?
I'll move to pass.
Motion to pass from Senator Parent. Is there a second? Second from Senator Steele. All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
I don't know, would you like to, sir?
Sure, I can. Why not? Why not? I wore rabbits today. Are they considered pets too? I guess they could be.
No, if you don't have a dog like I do that likes to chase rabbits.
Yeah, mine's too old to do that now. She wouldn't make it, so a rabbit would outrun her.
Thank you so much for that means a lot.
Happy to do it. Thank you for your work on this. All right. Okay, going back to the agenda, House Bill 85, Chairman Leverett. We are working on the version that passed the House, LC 473366S. Is that what you have?
Yes, Mr. Chairman.
All right, the floor is yours.
Thank you, Mr. Chairman. Thank you, members of the committee. And thank you again, Mr. Chairman, for your very kind and prompt consideration of my legislation this year. This is a bill that is a companion to House Bill 86, which the committee heard last week. That was a bill that would reform the structure of pay for our statewide judges, the judges that are state employees who have statewide jurisdiction. This bill applies to Superior Court judges. And those judges, although they are elected from circuits and generally serve in those various circuits, they are state employees. They receive a state salary. And this bill would reform the structure of that salary. It does not appropriate money. It does not mandate that they receive any amount. Just as with the bill last week, we are striking from the code the dollar amount set for their pay and replacing it with a cap that is expressed as a percentage of an index. And the index is what the U.S. District Court for the Northern District of Georgia was paid 2 years ago. So it's not mandating they receive that pay. It's simply setting that amount of pay as a cap. It also would restrict the use of supplements. It would impose a 10% limit on them, and we actually technically do away with supplements and replace it with locality pay, but that's basically a supplement. It's just limited to 10% of whatever the state pay is. There is a provision in this bill, however, for an I guess it's not an opt-out, it's an opt-in. You have to opt in to this new system because there are some judges, and this is kind of part of the issue we're trying to tackle with this bill. Pay in the state of Georgia, the state portion of the judicial pay is, I believe it's 49th in the country. I think West Virginia is the only state that has a state portion of pay less than us to their judges. But because of the supplements, some Superior Court judges in our state make about the 5th or 6th highest in the state, in the country, in terms of their compensation. I believe there are even some who in the past have made more than the Chief Justice of the Supreme Court. So we're trying with the use of this cap and the index to not only restore some uniformity to what Superior Court judges get across the state, but also to, I guess, impose sort of some rational hierarchical structure in that pay with respect to Superior Court judges and as you move sort of up the ladder to statewide business court, court of appeals, and so forth. But as I mentioned, for those of you who may have judges who have pretty good supplements, there is an opt-in provision, so they don't have to opt in to the new system if they don't want to. Last year, this committee did not hear the bill, but there was a provision that put a deadline on when you could opt in, and if you didn't opt in, you were opted in at that point. That's been taken out. We also have a provision that provides that locality pay will phase out if the state portion of the pay gets above a certain level. And that was Chairman Tillery's concept, and we've adopted it in this bill. And finally, as for many of us have local jurisdictions that tie pay of local officials to what a Superior Court judge is paid, either as a percentage or to equal. Considering of the possibility that we will hopefully on the appropriation side begin to appropriate more money to our judge pay, that could be disruptive of local jurisdictions that have set their pay by what a Superior Court judge gets. So we had a section in the bill last year, which we preserved this year, that basically suspends that linkage for a year, so that the local jurisdiction can either take their own action if they set that pay by ordinance or resolution, or can have one of their legislators file a local bill if that salary is set by a local bill. So it gives them time to respond to it, and the timing of that varies, whether it's a local judge, not a state paid judge, or some other local official. But basically the idea is the local jurisdiction is given some time to adapt and make some adjustments. So that's, I know it's a rather long bill, Mr. Chairman. I'm glad to answer any questions or go into greater detail, but that's just an overview. I know you've got a busy agenda, so I wanted to be respectful of your time.
All right, appreciate your work on the bill and Superior Court Judges Council for their work. I know it's been a long process. Thanks for coming back and continuing to work on this and getting this to the place it is.
I should say this was not my innovation. This was from the Council of Superior Court Judges and the Judicial Council as well. That was where this structure was derived.
All right, any questions from the committee for the author? Do you have a question from Senator Kennedy, Pro Tem?
Thank you, Mr. Chairman. Thank you, Chairman Leverett, for presenting this. I think you kind of started answering a question that I had, and if you could just unpack it a little bit more. What is the difference in what we used to call supplements and what's contemplated herein as locality pay?
Well, one could say there really is no difference except a locality pay as a supplement that is more restricted than it has been in the past. I think right now there's a statutory restriction of supplements. It can't be more than $50,000. We're striking that from the code, and we're basically doing away with the concept of supplements in name, but just replacing it with locality pay. So it's basically the same thing. It just is limited to 10% of whatever the state paid portion of the salary is. And as that salary goes above a certain level, it's in the, I think it was 200 and, let's see, hold on. If you'll bear with me 1 second, I'll try to find that number. If the pay exceeds $201,060, which is 90% of what U.S. District Court was paid 2 years ago, so it would be the current cap amount. Then there's a phase out, and you start phasing out the locality pay where it starts reducing as the salary goes up. And I believe it's at about 240 something locality pay would go away. So all the judges would be paid basically the same thing statewide. We're not at that point, but that's the idea. So I suppose the short answer to your question is it's sort of a rose by another name, but it's just limited with respect to the proportion of the state pay.
Follow up, Mr. Chairman. So is the driver behind that I know we're trying to get uniformity across the board, which I think is a good idea. I get that the variation, though, within the pay of those that are in the system would be no more than 10%, as some districts may elect to give a full 10% locality pay, some may not. So now that we've closed the gap on that differential,
That's
is
correct.
That's
correct.
what we're
The
trying
idea
to
is
achieve?
We're to start out with, we're not eliminating completely. We're still allowing for some variation, but it's going to be much less than it is currently. So we're starting to fix the problem, and then based on the comments of the Senate Appropriations Chairman last year, we've decided to phase it out completely. The idea is if the state pay keeps going up and up, that eventually you wouldn't need any locality pay to attract and retain judges.
Okay. Thank you.
Thank you. Thank you for the question.
Any other questions from the committee? Senator Cowsert?
Thank you, Mr. Chairman. I was a little late arriving, so I hate to rehash this, but is this like the appellate court judges based on the federal district court?
Yes, sir.
Okay.
Yes, sir. It's just a different percentage because it's Superior Court judges.
And is it also according to appropriations, or is this more rigidly tied to them?
Is it what?
Based on appropriations or more rigidly tied to the federal judges' pay?
Well,
On the
it
appellate
is-
judges, it could be up to 99%. I don't know that I saw that same language in
Same
here.
language here, it's a cap.
Okay.
We are not appropriating money, we're not committing to pay any money. We're actually changing it for the worse in a way for judges because we're taking out sort of the dollar amount that's statutorily required and replacing it with a cap. So we're taking out sort of an amount and replacing it with a maximum you can't go above.
If I follow it. But am I right, the prohibition against reducing judges' pay still stands? So
It-
if
within
one
the
year
same
we take it
term.
up?
Yes, sir, within the same term. That is constitutional.
Okay. I'm personally not comfortable tying us to a federal standard. I understand you've got that leeway, and if I were the judges, I wouldn't be so happy that it
Well, let
would
me
be
just say, this
changed.
was their idea. They're happy with it. I understand the chairman will vote as he deems his conscience best, but this is something obviously the judges would like. They feel it'll bring more uniformity to their pay, and just myself as someone who occasionally appears in court, not that often, as you know, it will hopefully help stem what we're seeing as some attrition in the ranks from people going due to the leaving and going into the private sector because of those competitive salaries.
What's the base pay now for a Superior Court judge, state salary?
I have that, Mr. Chairman, and I'm not.
You know, it's an old number in the code that's gone up and up and up with inflation and stuff, adjustments that I don't think you can just look at the code section and really get an answer these days.
Yeah, the code section, to your point.
Got to be the code that you're amending.
Yeah, I'm having trouble finding it here. Let me check my notes, Mr. Chairman.
Yeah, Mr. Walker. I'm told from my lifeline it's 144,000, which includes drug court pay.
Okay.
Sounds right. I believe the current number in the code is 126, but I think
I was gonna say I thought it was 125 in the code, 126 in the code, but there's other, as you said,
Yeah.
other money's included in that, so it's 126 currently in statute. Then
So it's a 35% raise.
no, it is not a raise. It's a cap. This is not an appropriations bill. We're not obligating ourselves to pay anything to them. We're setting a cap so that if we do approach the cap, or if we don't approach the cap, we've got some sort of structure in there to sort of graduate the pay among the different classes of court. And hopefully, now, I will say though, the ask, as you know, is to increase the state commitment to judges. The idea being, we ought not to be number 48. We ought to do a little better than that. But this bill does not obligate that. It just sets up an infrastructure where that could happen if judges opt in. So I understand your concern, but this does not obligate the legislature to appropriate money. And I would say I think that's part of the genius of this structure. Some of the people on this committee, I think, used to serve in this body, and they know how jealous we guard our appropriations authority. We're covetous old sinners when it comes to that.
Do they realize how concentrated that power is?
And what?
In who sets it? Who
And who
sets
sets
forth what the
appropriations? I think
appropriations are. Yeah,
last year
it's
they really learned a good lesson in how concentrated that is, Mr. Chairman.
any further questions from the committee?
As did the sponsor of the bill.
All right, no one signed up to speak on the bill. What's the pleasure of the committee? Motion to pass, and the pro tem, is there a second? Second from the floor leader. All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
Florida Hatchett.
Floor Leader Hatch. All right. Thank you.
Thank you, Mr. Chairman.
Stay where you are because you've got quite the show today.
I do.
And apparently maybe more show this week. We'll see. House Bill 327 next in our stack. We are working off of the version that passed the House, LC 4815116S. Is that what you have?
Yes, sir.
All right, the floor is yours.
All right, Mr. Chairman. This is, I guess I would call it what we affectionately call such bills around here as a bar bill. This is from the fiduciary law section. So that's the section that handles or sort of involves folks whose specialties would be probate, wills, trusts, charitable giving foundations, that sort of thing. So we're dealing primarily with Title 53, but this bill sort of roves through the code in a number of different places, basically trying to clean up and make consistent different provisions in other codes so that the probate code and the trust code is consistent. So, for example, we have some provisions in here that deal with that notice to beneficiaries statute that we passed a few years ago to try to clean that up. We've got some amendments to the banking title because there are some provisions in there that deal with trust funds and trust accounts, and we're trying to make those consistent. There's even provisions in the domestic code that deal with legitimation and other proceedings like that where you determine who heirs can be if they're legitimated, and we're trying to make that all consistent. And then we're just doing some different cleanup in the probate code itself. It's an extremely long bill. I have an experienced trust attorney here who can go through the bill with you section by section or can answer questions you may have about particular sections. But in House duty, we went through the bill section by section. It was, I think, fairly vetted there. Nobody pulled out a photo of a pet, least of all me. Although I'm glad to do that, Mr. Chairman, if you'd like to see, and have about 45 minutes to see all the pictures on the phone. But I believe it's been thoroughly scrubbed by the section itself, by the fiduciary section. If any of you ever spent time with trust and estate lawyers, you know that is a skill they possess to a high degree.
Well, I was going to say this is one of the great things the state bar does for us is gathers experts who practice in these areas most of us don't always touch. Have a couple partners that love this stuff too, and they vet these things in the off season and bring them to us, and it's a lot of work that goes into it. It looks simple when it gets here, but a lot of the work or all the work really is on the front end. So appreciate. I know we have, is it James Hash that's with us? Do you want to come up?
Mr. Chairman, happy to answer any questions.
Okay.
There's no objections.
All right, he's happy to answer any questions. If there's no objections, I think he's in favor of the bill, of course. Any questions from the committee, particular parts that the committee wants the author, Mr. Hash, to dive into deeper? Let us know. All right, what's the pleasure of the committee? Motion to pass from Dr. Watson. Is there a second? Second from Senator Steele. All those in favor, please raise your hand. It's unanimous. It sounds like a pro tem bill to carry. Is that who's carrying it? I had to guess.
I believe, yes.
Your mic's not on.
I've enjoyed it so much, Mr. Pro Tem, as I know you have very
It
patiently.
reminds me of those banking bills you bring us every year, you and Bruce Williamson. So I thought about you when I saw it. All right. Last one for you today. House Bill 530. We are working again off your House version, LC 481457. Is that what you have?
That's it, Mr. Chairman.
All right, the floor is yours.
This is simply a bill. It's patterned after the statute in the Superior Court Code that would provide for electronic filing in probate courts. So we've made some changes, obviously, where there are provisions of that statute that wouldn't apply to probate court. But it basically would provide that on or before January 1, 2028, the judges and the system will come up with an electronic filing system and a vendor to allow for electronic filing in probate courts. And actually, I have one or two changes at the appropriate time I'd like to ask for, Mr. Chairman. to make this sort of mandatory by that date. But the bill, if you'll go through it, it just simply addresses restrictions on the vendor on what they can charge and how they can charge, and certain things they have to exempt from their charges. And it just is patterned after the Superior Court statute that accomplished the same thing in Superior Courts. So it's fairly straightforward, but I'm glad to answer any questions to the extent the committee has any.
This is one of those bills where, at least for me, my staff loves these kind of bills because it makes life easier in a law firm where you're trying to run documents, run filings over to courts that aren't doing stuff electronically. So definitely, I think my office back home loves this bill. I can say that much.
Well, that's good. That's an endorsement.
Do you want to add anything to it?
No, my name is Keith Wood. I'm the probate judge in Cherokee County. I'll certainly answer any questions, but I mean, this is a bill that the probate council has put together, and we're obviously for it.
Yes,
Thank
I
you,
should
Judge.
say that it's not my initiative. It's one they've.
We gathered that. Yeah. You have a question from Chairman Cowsert?
Just want to make it clear, because I can't decipher everything here this fast. This is mandatory now to be electronic?
It would be, yes, as of January 1, 2028.
Right now, are you allowed to file electronically if the court provides that service?
I would defer to the judge. I know in my jurisdiction, we don't have electronic filing in probate court.
Senator, there are some counties that do currently have e-filing, and then they allow people to e-file. I don't think it's obviously not mandatory as far as I'm aware in those counties, but there are counties that are already doing it. And the goal is to try to make that uniform.
My firm's the opposite of Mr. Strickland's firm, Chairman Strickland's. We're paying over $3,000 a month now in filing fees in various cases when it used to be $0 for the defendant. Yours is a little different in probate court, but this has shifted the cost from the plaintiff to the defendant in civil litigation, and it made it mandatory to file electronically. What I don't worry so much in, we're pretty sophisticated practices in civil litigation and repeated. But in probate courts, a lot of it is pro se. A lot of it is unsophisticated people that may not have computers. I hate taking the option away from them of going in your office and, filling out the petition for letters of administration or whatever it might be. I just don't know that we're not, by making it mandatory, I'm not nearly as comfortable. I guess you guys thought that through.
Senator, I think that I understand the concerns. I think that you have mandatory e-filing in state and superior court and civil proceedings. There's plenty of people that are doing that pro se in those courts as well, divorce proceedings, you name it. I think that, we tried to leave when we were thinking about this, we tried to leave it broad enough so that we're not, that each court can kind of manage that how they think they can, whether it's to have a kiosk in their office, which I know in our court, in our superior court, that's what they have, so the people can come in. If they want to e-file it there, they have the option to do that. I think, it's going to be how the court wants to approach it, but I think that we recognize that we have plenty of self-represented litigants, and I think the courts will try to make it as feasible as possible for those people, recognizing that that's our clientele.
Do you have a follow-up on that? That was actually one of the follow-up questions I was going to have. So when we did it mandatory for superior and state courts, my understanding is someone that is pro se, and you mentioned especially divorce cases, if they walk into a courthouse with a filing, you may not know the answer to this, is there a requirement now that there has to be a computer available where someone can use the system in the courthouse and still file, even though it's electronic?
I believe in most superior courts they do, and there is a provision in here that references that.
That's what I was going to ask you. How are we going to do that for probate
I don't know that it
courts?
specifically requires it, but it does contemplate that there would be you would make filings electronically at the courthouse via public access terminal in the clerk's office. That's lines 54, 55. It says the subsection shall not apply to filings in connection with filings made electronically at the courthouse via public access terminal in the clerk's office, but I think it still contemplates you would file electronically, so that it would be there for you to use the terminal in the clerk's office.
Because I do think that is important, especially with probate courts. This is the court that has the most people, my understanding, walking in who don't always use lawyers, that they could still walk in and not be sent back home to try to figure out something online. They could still do it. Is that the intent, that you just have access at the courthouses?
That would be, I think that would be the best policy, and I think that that's probably what most courts are going to end up having to do. And then, having it mandatory allows us to, that way, some of the counties that can't persuade their county commissions to give them the ability to do that, they have now something to leverage
Right.
that.
Leader Hatchett?
Thank you, Mr. Chairman. So I may be reading this incorrectly, but it looks to me that what we're saying in this bill is that the probate courts shall provide the means, or shall provide for the electronic filing, but this isn't necessarily a prohibition on filing in person.
That is correct, although I have an amendment that would require.
Oh, you're going to get that. Okay. I was going to say we could address Chairman Kauser's concerns with that.
But the current draft would not make it mandatory in that sense.
That's true. Without the amendment, it would not be mandatory.
All right.
Just
Leader Jones, was it you? Senator Rhett?
I think they answered my question. I was just wondering if there was a drop dead date for everybody to be online, or if it's a gradual work-in. Because
The date is January 1 of 2028. It's at the very beginning of the bill. So that is basically intended, I think, more to compel the judges to do it than it is the litigants.
All right, no other questions from the committee. Do you want to talk about your proposed amendment?
Yes, sir. So the proposed amendment, which, given some of the questions, may not be satisfactory, but the proposed amendment is we did want this to be have it required. So it would be on line 13, toward the end of that line, after all probate courts shall provide for the electronic filing. All probate courts shall provide for and require the electronic filing of all pleadings. And then at the end of that page, at the end of in line 16, just before the period, after payments and remittances by electronic means, we would add through the court's electronic filing service provider, just to clarify that.
So just coming from me, and we can entertain any amendments anybody wants to bring, I'd like the assurance that someone that walks into a probate court can still file on the spot, because that is the court that is, again, the most foot traffic, my understanding, all the things that you have going on there. In my experience, most people don't hire a lawyer to deal with an estate every time. And so in other proceedings that people bring without lawyers in our probate courts. So what's the assurance that we make it mandatory that you would have access still for people to do that in the courthouse? We'd have to just rely upon courts doing that, basically.
Yeah. Mr. Chairman, I wonder if there was some language in the Superior Court.
That's what I was wondering, because my understanding is that's how it works in state and Superior Court, but I don't know. It's how it works in practice, the places I've seen. And others may want to weigh in on a proposed amendment. If it's not going to be offered, then maybe it's no point in discussing it further. Leader Hatchett.
And I have the utmost respect for Chairman
But
Leverett, but I don't think I could get on board with this amendment just how it is right now.
it probably makes more sense to get this set up, and then we can make sure we have a way to.
I think that might be for the committee's time, that we just see if
That
we
makes
can
more
get the bill
sense.
passed as is, and then we can come back and fine tune it. We've got a couple years here, so.
Right. All right. No one else signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Leader Hatchett. Is there a second? Second from Dr. Watson, and third from Senator Rhett. I always want to call you Dr. Rhett. All those in favor of the motion, please raise your hand. You got a unanimous vote. Who's carrying the bill in the Senate?
I don't.
Let's see who makes eye contact. Oh, Leader Hatchett falls for it every time. Leader Hatchett will carry it. It's the governor's bill now. You don't get a lot of power as chair, but that's the one I seem to always get away with. All right. That's all you have, right?
Very much, Mr.
Oh, they don't have a fourth one, do you?
Greatly appreciate it.
Thank you. Appreciate your work. Chairman Smith, come on up. House Bill 535.
Thank you, Chairman.
We are working off the version passed the House, 481478. Is that what you have?
Yes, sir. I
The
have
floor is yours.
the version that passed the House, not a substitute that didn't, so.
Yeah.
I bring to you House Bill 535. This is actually dealing with the probation time served calculations. Kelvin decision kind of got a little out there, and so we're trying to fix what the Court of Appeals across the road did. This, in almost all contexts, Mr. Chairman, if a person is sitting in jail awaiting adjudication of a case, Georgia law dictates that their time sitting in jail counts as time served if they're sentenced to more jail or prison time. This bill provides a very simple fix, and that would count time served for probation revocation cases the same way as any other case. This is how courts counted time served for years before the Court of Appeals decision created the legal fiction that time in jail only counts as time on probation for purposes of time served calculations. I can probably note that Senator Cowsett and myself have to deal with this a good bit in our practice, and so this puts us back where we need to be in Georgia Code for time served purposes.
All right, any questions from the committee? No one speaking in opposition. Wade Askew's for the bill, but he waves because he reads the room always. What's the pleasure of the committee? Motion do pass from Chairman Cowser, second from Leader Jones. All those in favor, please raise your hand. It is unanimous. Who's carrying the bill in the Senate?
Senator Cowsett, do you want to carry?
All right,
Thank
Chairman Cowser. Thank you. Appreciate it, Mr. Chairman.
Thank you, members of the committee.
Thank you for your work. Yes, sir.
That citation of the Court of Appeals case,
Be good to have.
just as I prepare to present. Thank you. Appreciate it.
Thank you. All right, Chairman Blackman, come on up. House Bill 222. We are working off of the S-Pass version 481345. Is that what you have?
It is,
All
Mr.
right,
Chairman.
the floor is yours.
Thank you, Mr. Chairman, members of the committee. This particular piece of legislation, a little bit out of my area of expertise, was brought by our county clerk, Teresa Hathaway, and asked that we add some additional communication components, I guess, between the court and the principal and the surety. I think it's intended just to improve communication. Happy to try to answer any questions.
We should have taken these bills first, right? That's what you were thinking. You
Well,
didn't want to say it.
Explanation was probably longer than the bill itself.
No, it makes sense. Any questions from the committee? No one signed to speak on the bill. What's the pleasure of the committee? Motion do pass from Senator Redd. Is there a second? Second from Chairman Cowsert. All those in favor, please raise your hand. It is unanimous. You don't come to Senate Judiciary that much. You came last year, though, for a bill, too.
Well, you were very kind last year, as a matter of fact, and I had obligation back home that you took care of.
I do remember
so
that
thank
because
you,
I have
Mr.
the same
Chairman.
obligations I deal with. So I'm very sympathetic. You have twice the drive I have. Well, I was going to say we're not always this easy, but this time we were today. So who's carrying the bill in the Senate?
Senator Walker.
Okay, Senator Walker.
So thank you.
Thank you.
Thank
Appreciate
you, Chairman,
you.
members of the committee.
All right, Representative Martinez, House Bill 325. Come on up. Again, we're House version working off of 461038. Is that what you have?
That is correct, Chairman. Thank
All right,
you.
the floor is yours.
Thank you, Chairman and committee, for being here. I'd like to present HB 325, and next to me I have Army National Guard Judge Colonel Brian Bischoff here in support. And this bill basically allows a military judge to enter a military protective order against guardsmen who is an alleged perpetrator of a crime who is now stalking the victim. Unlike protective orders that is currently available, this order would apply to the guardsman who is alleged perpetrator 24 hours a day, 7 days a week, regardless of what duty status he or she is in. This gives the guardsman who is an alleged victim the same protections they would if he or she would be on an active duty installation. This bill also gives the alleged perpetrator due process by giving him or her an opportunity to present a defense prior to the issuance of the protective order that could negatively affect them. The proposed statute only applies to service member allegation. This bill does not apply to civilian on service member or service member on civilian allegations. The proposed legislation addresses service member stalking to protect the good order, discipline, and morale of the Army National Guard. MPOs will be enforceable through our military judge and or courts martial. This bill gives the military judge the contempt powers to compel obedience to the MPOs in the same manner and subject to the same limitations as authorized in Georgia civilian courts. Provision include up to 30 days in confinement and a fine of $1,000 under HB 25. MPOs will be lawful military orders, also subjecting violators to charges and punishments under the Georgia Code Military Justice for failing to obey an MPO. I must say that our good friend Joe Ferreira, Admin General, is in support of this. Of course, Mr. Bischoff, with Brian Bischoff, with the judge with the Army National Guard, is also in support, and Lieutenant Colonel Ed Piesta is also in support of this bill. So with any further, I'd like to ask for any questions, and I got my standby here to answer any questions that you may have. Thank you.
Colonel, thank you for your work on this as well. Any questions for the author of the bill? Senator Kauser.
I feel like I always have a question of some
somebody
sort.
needs to ask something. We can't go this fast.
Yeah,
So.
I am just curious, what happens now without this law? If a guardsman claims that somebody's stalking them, do they just go to our civil court system, or what's their remedy now without this additional military solution?
Exactly. Colonel, would you like to answer that?
Sure. Thank you, Senator. I appreciate the question. First of all, let me clarify. I am the state judge advocate for the Georgia Army National Guard. We do have a military judge, Colonel Kyle Pearson, is a traditional soldier. He's actually the executive counsel for DNR in his civilian job. Couldn't be here today, but I want to just point that out. So right now we have a couple of options. We have a military protective order process that was developed by the Federal Department of Defense. It allows any commander to issue a military protective order that on the active duty side, where you're 24/7 a soldier all day, every day, is a very convenient and effective way to handle those situations. 85% of our force is not that. Right? 85% of our force comes in 2 days a month and 2 weeks during the year. So if we have a commander issue one of those orders on a drill weekend, the 2 days that we're there, then as soon as Monday comes, it's no longer a lawful order, all right? So there's issues with that that we're trying to cure here. In addition, we're supposed to enter that into the NCIC database. Well, that presents huge issues and concerns for me as an attorney for the due process rights of the respondent. We're going to issue an order into NCIC where, if it, again, we have civilian jobs. So let's say that respondent works as a teacher or works as a law enforcement officer in his civilian job, where they do routine background checks. And they do a routine background check and discover that there's a protective order. Well, we're a right-to-work state, so they can be fired on the spot with no due process. That's not something the active duty has to work to be concerned about. So typically what we do now is we issue what's called a no-contact order, which is essentially a counseling for that person saying, hey, you shouldn't have contact with this person. You're not to have contact with this person during a duty status. And we also point out that even if you're outside of a duty status, if you were to have contact with this person, it has the potential to affect negatively the good order and discipline of our Georgia National Guard, which gives us some ability, albeit tangential, some ability to punish them with a violation of what's called our general provision of the Georgia Code of Military Justice, which is Article 134, 38-2-1134 is the code section. Again, it's not a great alternative, but it's something that we use right now. This obviously allows our military judge to issue something that would be in place 24/7 and allow enforcement mechanisms that are far greater than what we have right now. Hope that answers your question.
Well, I just wondered, what would a service member have the ability to use the civil
absolutely.
Court
and
system
they still
if they
will.
wanted to?
Absolutely, Senator. They can go to a courthouse and just like any other citizen can, and apply for a temporary protective order, a permanent protective order, using the same grounds that they can on the civilian side. What this does, we do often have folks who don't want to do that. They don't want to go through the civilian process. This just gives them another option that allows them perhaps a smaller audience and less folks involved than potentially would be on the civilian side.
But am I following that it would still be enforceable even when they're not on their weekend training or whatever? It would apply to them in their
Absolutely, yes.
civilian life as well?
Absolutely.
Okay.
Senator Parent?
Thank you, Chairman Strickland. Thanks for the bill. Curious if there was any sort of particular situation or if incidents were escalating over the last few years that prompted this. I'm sort of surprised we didn't have it already.
Appreciate the question, Senator. There's nothing that's been escalating. So where these typically come into play is when we have an allegation of sexual assault. So our service members have the ability to file a report of sexual assault that is either restricted or unrestricted. If it's restricted, they go to our victim advocate or our sexual assault response coordinator, and it's really just so they can get some behavioral health, mental health resources to help them. If it's unrestricted, as we're going through the process, we tell them that they have the ability to request a military protective order, or they can go through the civilian protective order process. And again, when I say military protective order in this context, I'm talking about the one that's issued by a commander that was developed by the Department of Defense. We are required to tell them that. So a lot of times what I see as the state judge advocate is we'll get those requests, and there's really no basis for the request, no evidence to support that there's a danger. It's often just, hey, I'm alleging a sexual assault. I don't want to see this person. This person hasn't tried to contact me. This person hasn't been stalking me. This person hasn't been talking to other witnesses. I just would feel more comfortable with a piece of paper that says he shouldn't contact me or she shouldn't contact me. And so we get those, and that's where the due process part comes in. So typically I'm not going to recommend that an MPO be issued in that scenario. What this is for is on those rare occasions where we do have concerns for safety of our soldiers and they do present that evidence, we want to make sure that whatever we put in place is enforceable 24/7, if that makes sense.
Thank you.
Any other questions from the committee? All right, thank you. Thank you for the explanations you gave there too. What's the pleasure of the committee? Motion to pass from Senator Steele, a second from Senator Parent. All those in favor, please raise your hand. It is unanimous. And this is one I'm carrying for you?
Yes.
All right.
Right, Chairman.
Thank you.
Thank you.
Appreciate you. Thank you. All right. Representative Seaball, thanks for sticking around. Come on up. You drew the short straw today at the last bill, but we're only an hour in. It's not so bad.
Hey. Glad to be here.
Working off of the version that passed in the House, 560-363S. Is that what you have?
That's correct.
All right, the floor is yours.
Thank you, Mr. Chairman, committee. my good friend Senator Rhett from Cobb County. It's great to be here. The purpose of this bill is to provide legal clarity and fairness in the administration and enforcement of the peace officer's oath by doing the following. It standardizes and codifies the oath of office for which all peace officers in Georgia take. It ensures only legally codified oaths have binding effect, and it limits criminal liability for oath violations to serious offenses. So why is this necessary? This amendment provides legal clarity and protects due process for public peace officers by clearly distinguishing between binding legal oaths and aspirational language that was never intended to carry legal consequences. Without this clarification, officers could face criminal charges for violating non-codified or vague oath language, opening the door to inconsistent enforcement and over-criminalization for minor or non-criminal actions. So HB 384 is significant in that it ensures that only serious criminal conduct by a peace officer leads to revocation of the officer's certification, thereby ending their legal ability to serve in law enforcement in Georgia. We're protecting our officers from losing their careers over minor or technical violations of aspirational language that gets entered into some of these oaths. So that is the bill, Mr. Chairman. I'm happy to answer any questions.
Any questions for the author from the committee? Mr. LaRusso, I know you're here to testify as well. Do you want to add anything?
Just very briefly, I appreciate the committee's time with this. This is something that I have looked at for a long time. Just about every state has some sort of a violation of oath statute. We take oaths very seriously, and we want to prosecute them if they are violated. Just about every profession has aspirational language. The bar has a great deal of aspirations in our rules that have no force and effect other than to hold us together as a profession. So this would apply to all public officials. The violation of oath of office statute references any public officer. So this would standardize the oath so we don't have someone indicted for a felony for violating a report writing rule or a small crime, even an ordinance or a policy and procedure of the jurisdiction. So it standardizes it, very much makes it very similar to other agencies. And keep in mind, anytime a public official is sanctioned, almost all the time there is another body that is looking over their shoulder, whether they're firefighters, peace officers, corrections officers. There is another body that's reviewing their conduct.
All right, thank you. Questions from the committee? Senator Steele.
Thank you, Mr. Chairman. Thank you for the explanation on that. Representative Seabaugh, can you, I'm just asking this for understanding line 43 of the bill. An agency may administer additional oaths that contain provisions not specifically prescribed and enumerated in this code section. What would be some examples of that, or like what might that cover?
Senator Steele, I think I can grab this because I've looked at some of them. There are oaths that have what you would expect. I will abide by the constitutional laws of the state of Georgia. I will enforce the laws equally. And then I have seen aspirational things like I will abide by the policies and procedures of the county, the city. I will abide by the law enforcement officer's oath from the International Association of Chiefs of Police. Some of these are thrown in to give force and effect to the oath. But I've seen situations where the people that are swearing them have no idea what they are. They've been in there so long. And keep in mind, the policies and procedures can change with an administration change. They can change at the will of someone. So it's very difficult to know exactly what these procedures are. And a minor policy violation, showing up late, is a violation of policy and procedure.
Thank you.
Yes, sir. Thank you.
Chairman Calzert.
Thank you, Mr. Chairman. I'm curious what brought this on. Was there a particular instance where some officer was, untruthful or didn't follow their oath, but it was just a misdemeanor problem, not a felony problem? And I mean, is there a specific instance that generated this legislation?
Several. One of them is extremely high profile. I'll tell you in a moment. We have had officers who have been indicted for violating a policy along with other crimes that were misdemeanors, but now they're charged with a felony because of the policy. If an officer is driving a vehicle or a firefighter is driving a vehicle And they are operating not as an emergency vehicle. They are just any other car on the street. They cause a wreck and it causes a death. That is a misdemeanor vehicular homicide in the second degree. We have seen situations where those charges were stepped up to be a felony. We also had a situation where an officer was charged with murder, was convicted of murder, and that conviction was overturned because the prosecutor charged them with violation of oath of office predicated, the sole predicate was the fact that they had violated the use of force policy, and the Georgia Supreme Court reversed the entire conviction.
Okay.
Any other questions from the committee? All right, no one else sought to speak on the bill. What's the pleasure of the committee? Motion to pass from Dr. Watson. Is there a second? Second from Dr. Rett. All those in favor of the motion, please raise your hand. Leader Jones, are you for the motion or? Okay, for the motion? No. Okay, 1, 2, we have 5 in favor. All those opposed? We have 2 opposed. All right. Motion carries. Who's carrying the bill? In the
Senator
Senate?
Albers.
Senator Albers. Okay.
Yep. Thank you very much.
Thank you.
Thank you. Appreciate you. We'll have a committee hearing tomorrow at 2 o'clock unless we have some filibustering on the Senate floor and get put a little bit later. We have a 1-hour hearing tomorrow. And then next week, the plan is to have, I think, the similar schedule with these 2 hearings. Still have a lot of bills to get through. I encourage the committee, if there's any bills you see that you want to discuss with me about being heard that haven't been heard, please come see me about that. If you have any concerns, please come see me about that. Do you have anything, Senator Redd or Leader Jones? One of y'all push your button. Oh, sorry. Sorry. All right, with that, we're adjourned.